whenever we prepared for oral arguments when I was Solicitor General, we really tried to cover the widest spectrum of the subject area. I experienced in my oral arguments as Solicitor General the almost embarrassing situation of a justice asking a question that you would never expected would be asked. Because sometimes the questions do not really refer to the matter at hand. An example would be, an example would be the case of Miguel versus Gordon. Miguel versus Gordon involved the arrest of Camilo Sabio, chairman of the PCGG, and his incarceration at the Senate Infirmary. And so the executive director of PCGG filed this petition before the Supreme Court on behalf of Sabio. And the Supreme Court asked that this case be heard on oral argument. So, on a matter involving the authority of the Senate to arrest and incarcerate Camilo Sabio, the chairman of PCGG. So, the basis was, as we accepted the fact that this was supposed to be an exercise of the power of the Senate committee to hold a witness in contempt, because Sabio first refused to appear, and then later when he appeared, he refused to answer questions. Okay, so okay lang ako nun. Ayos na ako, okay lang ako. And then a justice asked me, Mr. Solicitor General, you of course remember from your law school that there are two kinds of contempt: criminal contempt and civil contempt. Okay. Which was really a departure of some kind from the power of contempt of the Senate committee. Yes, Your Honor. Secretary, yes, Your Honor. Will you please tell this court the difference between civil contempt and criminal contempt? And ipit ako doon. Ipit ako doon. And that is one of the things I advise lawyers who will argue before appellate courts. Never try to bluff your way into ano. So I have to admit na Your Honor, I'm sorry, I cannot make the distinction between criminal and civil. Okay lang naman ang justice. Alright, let's move on to another area. One of the most interesting things I argued while I was Solicitor General, of course, was the case of Lambino versus Commission on Elections, on the attempt by Lambino and his group to effect amendments to the Constitution through a people's initiative. Even as we were subjected to a lot of criticism then, because as Solicitor General, I refused to defend the position of the Commission on Elections, even if we were supposed to be the lawyers of the Commonwealth. The Solicitor General's office can do that. And so we argued along with petitioner Lambino and tried to convince the court of the validity of the proposed amendments to the Constitution through the petition filed with the COMELEC, which really had to do with the doing away of term limits, particularly the term limit on the President of the Philippines. yun. And so, we lost, of course, but it was a very, very slim loss. The vote was 8-7. When I recall what happened then, I would tell myself that history would have been different if the 8 went in our favor. There would have been no more Senate, because under the proposed amendments, the Senate would have been abolished. There would have been a unicameral Congress, and a parliamentary government. But God did not want this to happen yet. Nakakatuwa dahil this was one of the last cases I argued as Solicitor General.